Hello everyone, today I got a great video for you all. Today we have 50 court cases that shaped America. Now, the majority of these cases will take place here in the United States. There are some that take place in other countries, but they do have an effect on the United States. Let's get started. Now, this case predated the United States, but it affected the United States in some way. Number 50, the Crown versus John Peter Zenger. John Peter Zenger was the commissioner of the New York Weekly Journal. After Governor William Crosby fired Judge Lewis Morris, Zenger published articles and advertisements that mocked the governor. Crosby indicted Zenger on charges of libel and sedition. Zenger was acquitted of charges. This case led to the formation of the First Amendment of the United States Constitution, and the court case established that principle. It established the principle that truthful information is not libel. Number 49, Marbury B Madison. It was a court case in 1803. The Supreme Court case established that the principle of judicial review in the United States, meaning that American courts have the power to strike down laws and statutes that they find to violate the Constitution of the United States. This is number 49. Number 48, Liebeck v. McDonald's. Stella Liebeck, a 79-year-old woman, accidentally spilled hot coffee in her lap after purchasing it from a McDonald's restaurant. She suffered third-degree burns and was hospitalized for 8 days while she underwent skin grafting. It was painful, followed by 2 years of medical treatment. Liebeck's attorneys argued that McDonald's coffee was defective, claiming it was too hot and more likely to cause serious injury than coffee served at any other restaurant or establishment. Liebeck was awarded $640,000. This trial has been labeled a frivolous lawsuit, and it led to debates on tort reform. Is this case frivolous? I don't know. Number 47, United States versus Paramount Pictures. Landmark United States Supreme Court antitrust case that decided the fate of film studios owning their own theaters and holding exclusivity rights on which theaters would show their movies. The practice of block booking and ownership of theater chains by film studios constituted anti-competitive and monopolistic trade practices. Block booking was outlawed because it violated antitrust laws. The court case changed the way Hollywood movies were produced, distributed, and exhibited. They put it into the old Hollywood studio system. Why you go to the movie theater, they charge so much for tickets and concessions, because they barely see any of that money. Most of the ticket prices, most of the money they get from that goes to the studios. They just only make money off of the concessions. Like back in the day, the studio and the theater could share an equal amount of the revenue, but not today. 46, Mutual versus Ohio. Ohio passed a statute in 1913 forming a censorship board which had the duty of reviewing and approving all films intended to be exhibited in the state. Mutual Film Corporation sought an injunction against the board. Mutual argued that in addition to the violation of its freedom of speech, the censorship board was interfering with interstate commerce and that the government had illegally delegated legislative authority to a censor board. Those arguments were dismissed by the court. It became a landmark decision in the United States Supreme Court. They ruled a unanimous vote that free speech protection of the Ohio Constitution and the First Amendment of the U.S. Constitution did not extend to motion pictures. Number 45, Mutual versus Ohio was overturned in Burston v. Wilson. After the release of The Miracle, New York State Board of Regents reportedly received hundreds of letters, telegrams, postcards, affidavits, and other communications, both protesting and defending the exhibition of the film. The film was declared sacrilegious. Joseph Burston was the distributor of the film, and his license was rescinded by New York. New York had a law called the New York Education Law, which forbid showings of films that were sacrilegious. The The case was an appeal to the Supreme Court, and it determined that provisions of the New York education law forbid showings of films that were deemed sacrilegious, were restraint on freedom of speech, and thereby a violation of the First Amendment. The case overturned Mutual v. Ohio. This led to the decline of motion picture censorship in the United States. Number 44, Henry Gulf, court case 1967. The holding was that the due process clause of the 14th Amendment applies to juvenile defendants as well as to adult defendants. Number 43, TLO versus New Jersey. Teacher at Piscataway High School, New Jersey, saw a 14-year-old freshman and her companion smoking cigarettes. At the principal's office, TLO denied that she had been smoking and claimed that she did not smoke at all. The assistant vice principal demanded to see her purse. He found a pack of cigarettes, rolling papers, marijuana, a pipe, empty plastic bags, cash, and an index card that listed students who owed TLO money, and 2 letters that implicated TLO in dealing marijuana. The principal then called the police, and the girl's mother. She was convicted of dealing and use of illicit drugs. She was expelled from the school and fined $1,000. Supreme Court of the United States heard the case in a 6-3 decision. They balanced the legitimate expectation of privacy of the individual and the school's interest in maintaining order and discipline. According to the school officials, they do require a reasonable suspicion to perform a search. The Supreme Court established a standard of reasonableness for searches of students conducted by public school officials in a school environment. So you wonder why schools are so strict. You wonder why they can search your locker and your backpacks and tell you what you can't have, why you can't bring weapons, drugs to the schools, because of this case. They can search your stuff, they can take your stuff as long as they have reasonable suspicion. So thanks to TLO versus New Jersey, this is why schools are so strict these days. That's why your kids probably complain, why did school take my video game? Why did it take my pencil? Why did it take away my pocket knife? It's not going to hurt anybody. Well, because of this court case, they can. 42, Terry versus Ohio. Court case in 1968. The court ruled that it is legal for police to stop and frisk a person that they reasonably suspect to be armed and involved in a crime. Requires reasonable articulate suspicion, not probable cause. So if a cop orders you to get out of the car and they pat you down, they can do that. But they can't search you and take your stuff unless they have a warrant or probable cause. But a frisk only requires reasonable suspicion. 41, Mapp versus Ohio, Supreme Court decision in 1961, a case in which the court decided that the evidence obtained illegally may not be used against someone in the court of law by the Fourth Amendment. The exclusionary rule applies to federal government as well as the states. It's like the fruit of the poisonous tree. If a cop gets evidence illegally, they cannot use it against you in court. You have to get a warrant or probable cause and obtain the evidence legally for them to use it. Number 40, Gideon v. Wainwright, 1963 court case, a case in which the court held that the 6th and 14th Amendments guarantee a right of legal counsel to anyone accused of a crime. Right of legal counsel selectively incorporated to the states, meaning that states had to follow what the Supreme Court said. This is why in one of the amendments says you have the right to an attorney and counsel as well. 39, Miller v. California. 1971, Marvin Miller sent out a brochure advertising books in a film that graphically depicted sexual activity between men and women. 5 of the brochures were mailed to a restaurant in Newport Beach, California. The owner and his mother opened the envelope and, seeing the brochures, called the police. Miller was arrested, charged, and found guilty. Went to the Supreme Court, and they ruled that obscene material is not protected by the First Amendment. The court established a 3-pronged test determining obscenity called the Miller test. The laws on obscenity are very vague. And the state laws on obscenity vary, and the term obscene is very vague. So if you're going to prove someone of doing something obscene, you're going to have to go to the Miller test, look at your state laws, and you're going to have to determine what is obscene. It's vague. It's not really defined at all. So you can get away with obscene material if you can persuade the jury that your material is not obscene. If you're trying to strike someone down, you can say that their material is obscene by saying that it is some way, somehow. This is why YouTube, Twitch, and Twitter and all social media have strict policies, because they define what is obscene on their accounts. You could say it's not obscene, but it is their platforms and they make the rules. So, but you post obscene material and you pass the test and you are able to persuade the jury that your material is not obscene, I guess you could win and beat YouTube and social media once and for all. I think someone should use this case if their YouTube material or Twitch material is struck down due to community guideline reasons. But there's a chance you might lose as well. I don't know. 38, James Vance versus Judas Priest. December 1985, Raymond Belknap and James Vance spent 6 hours drinking, smoking marijuana, and listening to the metal band's Stained Glass album. After listening to the album, each man took a shotgun and shot themselves. Belknap died instantly, but Vance lived, sustaining serious injuries that left him disfigured. He died 3 years later. Vance and his parents sued the band and CBS Records for $6.2 million in damages. They claimed that Judas Priest had hidden subliminal messages in the song, but the judge dismissed the case. To me, this was all Vance and Belknap's fault. They listened to the music and they decided to shoot themselves in the face. Plus, they were drunk and high on marijuana. Please don't take what a band music is seriously. You know, listen to the song, like the song, but don't bow down to it like it's some sort of religion. All right? Most music, I don't think they have subliminal messages. To me, that's all them. That's all in their head. And whatever. Yeah, Judas Priest, they won the case, and they should have. You know, they didn't know someone was going to take their own life. You know, they didn't make the guy do it. They're just there to make a song and make money off of it. You're going to listen to someone's music, and if it has like profound language or suggestive themes, viewer discretion is advised. Number 37, Brandenburg B, Ohio. The KKK leader, Brandenburg, made a speech at a planned rally and was later convicted under an Ohio criminal syndicalism law. The law forbids speech as a crime, sabotage, violence, and terrorism. The Supreme Court held that the Ohio law violated Brandenburg's right to free speech. The court used a two-pronged test to evaluate speech acts. 1. Speech can be prohibited if it is directed at inciting or producing imminent lawless action. And 2, if it is likely to incite or produce such an action. Number 36, New York v. Quarles. A man named Quarles was stopped and was frisked by a New York police officer. When the officer saw an empty shoulder holster, the officer asked Quarles where his gun was. The officer then arrested Quarles and read him his Miranda rights. The Supreme Court established that a public safety exception to the requirement that officers issue Miranda warnings to suspects. If something dangerous on you that can be a threat to the public, they can ask you without reading you your Miranda rights. Number 35, Powell v. Alabama. 9 black youths were arrested for raping 2 white women. Alabama officials sprinted through the legal proceedings with 3 trials taking place one day. All 9 were sentenced to death. The Supreme Court held that the trials denied due process because the defendants were not given reasonable time and an opportunity to secure counsel in their defense. 34, Carpenter v. United States, 2018 court case. This is very recent. Government acquisition of cell site records is a Fourth Amendment search and thus generally requires a warrant. So they're going to search your cell phone calls or cell phone text messages or get information off a cell tower. They have to have a warrant. 3, Salinas v. Texas, 2013 court case in which the court held that the Fifth Amendment self-incrimination clause does not protect individuals that have not been arrested. So if a cop pulls you over on the street, your Fifth Amendment does not protect you, unless if the cop does arrest you. But if he asks you questions about what you're doing, you have to answer them. You can't just say, I plead the Fifth, or give him an incriminating response and expect not to be arrested for it. Once you're arrested, then you have the self-incrimination clause, but even that gets a little bit tricky. Number 32, Graham versus Florida, Tasmania court case, decision by the Supreme Court of the United States that stated juvenile offenders cannot be sentenced to life in prison without parole for non-homicide offenses. Number 31, Miller v. Alabama, 2012 court case. United States Supreme Court case in which the court held that mandatory sentences of life without parole are unconstitutional for juvenile offenders. Good. I think juvenile offenders should have the possibility of being rehabilitated and learning how to deal with their issues and problems and be reintegrated back into society safely. Number 30, Chambers v. Florida, 1940 court case. Convictions of murder obtained in the state courts by use of coerced confessions are void under the due process clause of the 14th Amendment. I don't know why I put clue there. I'll probably edit it out later. But it was the first case in which that court unequivocally declared the 14th Amendment meant that state courts would have to observe due process of law. Number 29, Indiana versus Ford. On their way to a church volleyball practice, two sisters, Lynn and Julie Ulrich, along with their cousin Donna Ulrich, were driving in a 1973 Ford Pinto. A 4,000-pound van tore into the rear Pinto, sending it flying into the air. The Pinto got fire, leaving the three girls deceased. Two died on the scene, and the other at the hospital. 6 months later, a notice from the Ford Motor Company stated a design flaw in their fuel tank system left in their 1973 Ford Pinto prone to gas tank explosions and rear-end collisions. Ford was criminally charged with 3 counts of reckless homicide. Ford was found not guilty, but agreed to pay $7,500 for each of the older girls. Ford was the first major American company to be charged with a crime. 28, Smith v. Wright, case in which the court held that it was unconstitutional for states to authorize political parties to create internal rules allowing discriminatory practices. The case presented the question of whether the Texas Democratic Party's policy prohibited blacks from voting in primary elections. Number 27, Boynton v. Virginia. The case overturned a judgment convicting an African-American law student for trespassing by being in a restaurant and a bus terminal, which was whites only. The ruling stated that the bus carrier provides the services of the terminal and its restaurant to the interstate passengers. These services must be subject to the same discrimination prohibitions as the transportation itself. Since the Interstate Commerce Act prohibits racial discrimination during travel, the same restrictions apply in these stations during stops. 26, Loving v. Virginia. The case in which the court held that the 14th Amendment prohibits governments from discriminating against individuals on the basis of race. The Supreme Court held that laws banning interracial marriage violate the equal protection and due process clauses of the 14th Amendment to the U.S. Constitution. This is why black people and white people can get married today and have mixed race children. I'm apparently one of them. Well, here we are, top 25. Number 25, Brady v. Maryland. John Leo Brady and Donald Bobbitt murdered William Brooks. Both men were convicted and sentenced to death. Brady admitted to being involved in the murder, but he claimed that Bobbitt had done the actual killing. The prosecution had withheld a written statement by Bobbitt confessing that he had committed the act of killing by himself. The Supreme Court held that withholding exculpatory evidence violates due process. The Supreme Court established that the prosecution must turn all over evidence that might exonerate the defendant to the defense. Brady sentenced to life in prison, but was later paroled. 2040 civil rights cases. A group of 5 landmark cases in which the Supreme Court of the United States held that the 13th and the 14th Amendments did not empower Congress to outlaw racial discrimination by private individuals. These 5 cases were United States v. Stanley, U.S. v. Ryan, U.S. v. Nichols, U.S. v. Singleton, and Robinson versus Memphis and Charleston. These cases were overruled by Jones v. Albert H. Mayer. 23, Brown versus Mississippi. The Supreme Court ruled that a defendant's involuntary confession as extracted by police violence cannot be entered as evidence. It violates the due process clause of the 14th Amendment. Number 22, Katz v. United States. The Supreme Court redefined what constitutes as a search or seizure with regard to the protections of the 4th Amendment to the U.S. Constitution. The court ruled that Katz was entitled to a 4th Amendment protection for his conversations and that a physical intrusion into the area he occupied was unnecessary to bring the amendment into play. 1, Illinois v. Gates overruled Aguilar v. Texas and Spinelli v. U.S., thereby replacing the Aguilar-Spinelli test for probable cause with the totality of the circumstances test. Totality of circumstances refers to a method of analysis where decisions are based on all available information rather than a bright line rules. Under the totality of the circumstances test, courts focus on all the circumstances of a particular case rather than any one factor. Number 20, Ohio v. Robinette. The Supreme Court held that the 4th Amendment does not require police officers to inform a motorist at the end of a traffic stop that they are free to go before seeking permission to search the motorist's car. Number 19, Board of Education versus Earl. The Supreme Court upheld the constitutionality of mandatory drug testing by public schools of students, particularly participating in extracurricular activities. That's why schools test people when they are participating in school sports. They have the right to. Can schools require you to get the COVID-19 vaccine? If they use this court case, they might be able to get away with that. That's why many schools require you to get vaccinations for other diseases when you enter the building. Middle school, they require you to get shots. Elementary schools require you to get shots. Same thing with colleges. College is a little bit different, but public schools do. You can thank the Board of Education v. Earls. Number 18, Georgia v. Randolph. The Supreme Court held that without a warrant, police had no constitutional right to search a house where one resident consents to the search while another resident objects. So if the police search your house and your mother consents, but your father doesn't, the police still need a warrant. All parties have to agree. Number 17, People v. Zarate. On July 1st, 2015, Kate Stengel was shot and killed while walking with her father and a friend along Pier 14 in San Francisco. The man who fired the gun was Jose Zarate. He said the bullet ricocheted off the pier when he found the gun. Zarate is an undocumented immigrant who was deported from the U.S. 5 times. Zarate was charged with murder and acquitted but convicted of being a felon. In possession of a firearm, but the conviction was overturned in 2019. Stengel family filed a lawsuit against the city of San Francisco and ICE, but they were dismissed. How nice. Important. Since the law was signed in 2017, this led to debates on immigration reform and sanctuary cities. Zarate is still awaiting a federal trial. I remember this case a few years ago. I saw a documentary on Kate Steele, and I was surprised at the verdict. I was surprised that Zarate was acquitted. That's San Francisco for you all. Sanctuary cities. They even have a homeless tracker app to track their feces around the city. Poor Gavin Newsom, man, he's really having a tough time during this crisis. He's facing recall action. Oh boy. 16, the Amanda Knox trial. Now, this case did not take place in the U.S. It took place in another country, in Italy, but this did affect the U.S. in some ways. Amanda Knox is from Seattle, Washington. That's in the United States. And on November 2nd, 2007, Wright of Kircher, her roommate, is found dead on the floor of her bedroom. Police charged Amanda Knox with murder. On December 5th, 2009, Knox was convicted and sentenced to 26 years imprisonment. On October 3rd, 2011, Knox was acquitted on appeal to the second level court. The prosecution requested another trial on January 30th, 2014. The court returned verdicts of guilty against the defendants. However, in 2015, the Italian Supreme Court definitively exonerated Amanda Knox. The real perpetrator was Rudy Guide. And it shows you how screwed up other countries' systems are. It just shows you how structured our systems are. Our systems are not perfect, but it is well structured compared to other countries. Other countries, if you're acquitted, they can appeal that and try you again. They can increase your sentence, decrease your sentence. Most countries do not have the double jeopardy clause like the U.S. or Canada or UK does. Each country controls their justice system differently. There's no transparency. And I kind of wish there was. 15, Ignato v. Ryan. Now, Ignato was charged with murder in 1991 following the disappearance of his girlfriend, Brenda Sue Schaefer. Jury acquitted Ignato. 6 months later, a carpet layer working at Ignato's house pulled up a length of carpet in the hallway. Under it, he found a floor vent containing a plastic bag. Inside the bag were 3 rolls of undeveloped film. When developed, the film showed Ignato torturing and raping Schaefer. Ignato was brought to trial for perjury based on his grand jury testimony. The case involved the protection of double jeopardy. You can be acquitted for a crime, but they cannot charge you with that crime again. Whoever can be sued or tried in federal court. There are loopholes to this. But regular acquittal in state court, the state cannot charge you again for that crime. To me, I think that, I do respect double jeopardy, but I think that if the state does have compelling evidence against you, I think they should try you again. Oh well. Number 14, Dred Scott v. Stanton. Number 14, Dred Scott v. Sanford. Supreme Court ruled that Americans of African descent, whether free or slave, were not American citizens and could not sue in federal court. The court also ruled that Congress lacked power to ban slavery in U.S. territories. The decision was overruled and superseded by Constitutional Amendments 13, 14, 15, and the Civil Rights Act of 1866. 13, United States v. Nixon, Supreme Court case that resulted in a unanimous decision against President Richard Nixon, ordering him to deliver tape recordings and other subpoenaed materials to a federal district court. The court held that the president does not have executive privilege and immunity from subpoenas or civil court actions. The case arose out of the Watergate scandal. Nixon resigned in 1974 as the first president to leave a resignation. Number 12, Bush v. Gore. The U.S. Supreme Court settled a recount dispute in Florida's 2000 presidential election between George W. Bush and Al Gore. The court found that the Florida government violated the Equal Protection Clause in ordering a partial recount of the 2000 presidential election. Bush won the electoral vote, but not the popular vote, making him the first in 112 years. This is considered one of the closest elections in U.S. history. Number 11, Plessy v. Ferguson. The Supreme Court codified the constitutional doctrine for racial segregation laws. In the eyes of the court, as long as segregated facilities were equal in quality, African Americans could be served separately from white population. This led to Jim Crow laws being enforced in the U.S. This was overruled by Brown's Board of Education. That is up next. We're in the top 10. Number 10, Brown v. Board of Education. Supreme Court ruled that U.S. state laws establishing racial segregation in public schools were unconstitutional, even if the segregated schools are otherwise equal in quality. This overturned Plessy v. Ferguson, and it paved the way for Martin Luther King Jr., Malcolm X, and the rest of the people in the civil rights movement. This is why you go to school today and see different people of races and diversity and ethnicity. That's because of this case. Without Brown Board of Education, Jim Crow would still be here. I would not be able to go to the schools I went to. I would probably be in a black private college somewhere. And my parents would not have adopted me because of this. Brown Board of Education is one of the most important cases in U.S. history. It has to be probably number one. I didn't put it number one. But it's good enough to make the top 10. Number 9, Tennessee versus Gardner, October 3rd, 1974. Memphis police officers were dispatched to answer a burglary call next door. Officer Elton Hyman went behind the house and witnessed someone running across the yard. Hyman shot and killed the fleeing suspect, Edward Gardner. Hyman acted according to a Tennessee state statute and an official Memphis Police Department policy authorizing deadly force against a fleeing suspect. Gardner's father then brought suit in the United States District Court for the Western District of Tennessee under Civil Rights Acts 1871 and 1983. The District Court ruled in favor of the officers, but on appeal, the U.S. Court of Appeals reversed. The Supreme Court upheld the appeals court decision. The Supreme Court held that the use of deadly force to prevent escape is an unreasonable seizure under the Fourth Amendment. Fleeing felon rules were limited in 1985 to non-lethal force cases. Number 8, Graham v. Connor. Supreme Court determined that an objective reasonableness standard should apply to a civilian's claim that law enforcement officials used excessive force while making an arrest. Objective reasonableness test was created. This means if you're going to sue a police officer for excessive force, you have to prove that they violated the objective reasonableness test. That is due to this case. Number 7, Miranda v. Arizona. March 13, 1963, Ernesto Miranda was arrested by the Phoenix Police Department. After 2 hours of interrogation, Miranda signed a confession to rape charges. Miranda was never told of his right to counsel, not advised of his right to remain silent, or he was informed that his statements during the interrogation would be used against him. He was convicted and sentenced to 20 to 30 years in prison. On June 13, 1966, the Supreme Court issued a 5-4 decision in Miranda's favor that overturned his conviction and remanded his case back to Arizona for retrial. This led to the creation of the Miranda warning, where the cop reads you your rights out on the street or when they're in the process of investigation. Miranda was convicted again, retrial in 1967, paroled in 1972. 1976, Miranda was stabbed to death in a bar fight. And how ironic. The person that stabbed him was read his Miranda rights, but Miranda wasn't. Number 6, Roe v. Wade. The Supreme Court, in which the court ruled that the Constitution of the United States protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. The debates of pro-life and pro-choice. Which side am I? I can see both sides. I would probably more lean towards pro-life, but if you're placed under extreme circumstances, I can see why you get an abortion. I might think it's immoral, but I'm not going to stop you from getting one abortion. You can get an abortion, but I'd rather you send the baby up for adoption and hope that he lives a better life than the mother had. But I'm in the middle. I can see from both sides. I think abortion is immoral, but I'm not going to stop people from getting one if they want one. Your choice is your choice. I might disagree with what you do, but to me, what you do isn't wrong. What's wrong is up to you. Number 5, Florida v. George Zimmerman. On the night of February 26, 2012, George Zimmerman was fatally shot. George Zimmerman fatally shot Trayvon Martin. Zimmerman was charged with second-degree murder. Zimmerman said that he shot Martin in self-defense, citing his injuries to his face. Blood dripping out his nose and his head. Is that his blood? Is that Trayvon's blood? Who hit who? We don't know. Since there was no video evidence, the only piece of crucial evidence was a 911 call that heard a voice screaming. Gladys Zimmerman, the mother of George Zimmerman, testified that the voice came from her son George. Tracy Martin, the father of Trayvon Martin, testified that the voice came from his son Trayvon. Vincent DeMaio, a forensic pathologist, testified that Martin's gunshot wound was consistent with Zimmerman's story of self-defense. 16 hours of deliberations over the course of 2 days. On July 13, 2013, a 6-person jury rendered a not guilty verdict on all counts. Opened people's eyes on police brutality and racism, led to debates on whether police should wear body cameras. This laid the foundation for Black Lives Matter. I remember this case about a decade ago. My mother told me that a police officer shot an African American. I was confused. I was like, why? What happened? Now, I didn't know all the details, but I remember the verdict. I was very shocked. I heard a 911 call. To me, that sounds like Trayvon, not Zimmerman. We don't know what happened. We don't know if Zimmerman was the instigator. We don't know if Trayvon was the instigator. We don't know. There's no video evidence. You have trace evidence. You have the 911 call. But in today's society, people are more digital than ever. They mostly rely on video evidence. At the same time, I don't think every piece of evidence should be about video. Because what video doesn't show you is the context. But here in the digital age, the jury is going to be focused on the video only. But since there's no video, it's tough to prove someone guilty. Do I disagree with the verdict? Yes. At least the officer was tried in front of a jury of his peers, which should have happened. They could not taken this case to court, but they did. Oh well. For Florida v. Casey versus Anthony. On July 15, 2008, 2-year-old Kaylee Anthony was reported missing, a 911 call, and made by her grandmother, Cindy. Said she hadn't seen Kaylee Anthony for a month, and that Casey's car smelled like a dead body had been sighted. Cindy said Casey had given varied explanations as to Kaylee's whereabouts, before finally telling her that she had not seen Kaylee for weeks. Casey lied to detectives, telling them Kaylee had been kidnapped by a nanny on June 9th, and that she had been trying to find her. She was charged with first-degree murder in October 2008 and pleaded not guilty. On December 11, 2008, Kaylee's skeletal remains were found in a blanket inside a laundry bag in a wooded area near the Anthony family's house. Prosecution alleged Casey wished to free herself from parental responsibilities and murdered her daughter by administering chloroform and applying duct tape. The defense team, led by Jose Baez, countered that the child had drowned accidentally in the family swimming pool on June 16, 2008, and that George Anthony disposed of the body. Casey was found not guilty of first-degree murder, aggravated child abuse, and aggravated manslaughter of a child, but guilty of 4 misdemeanor counts of providing false information to a law enforcement officer. She served 12 days in jail. The Florida Appeals Court overturned 2 of her misdemeanor convictions in 2013. Not guilty murder verdict was greeted with public outrage. Time magazine described the case as the social media trial of the century. The case was compared to O.J. Simpson's trial in 1995. I do remember this case from about a decade ago. Very confused as to what happened here, and I was surprised at the verdict. Did Kaylee drown? Did they hide the body? Was she murdered? We don't know. Just like Trayvon Martin, just like Florida versus George Zimmerman, there's no video evidence in here. You might have some trace evidence. This is a digital era, and without video evidence, the jury is going to have a very tough time to convict someone. Unlike maybe in the past, they probably would convict someone. Number 3, the state versus Oscar Pistorius. Oscar Pistorius, he was a professional sprinter, and he had both of his feet amputated when he was 11. Pistorius took part in the Summer Paralympics, came in 3rd place. 2005, he finished 6th in the non-disabled South African Championships. And at the Paralympic World Cup in the same year, he won the gold, beating his previous record. 2012 Summer Olympic Games on August 4th. He became the debut amputee runner to compete at the Olympic Games. He took 2nd place. He was given the name of Blade Runner and the fastest man on no legs. The stories have been the subject of criticism because of claims that his artificial limbs gave him an advantage over other runners. On Thursday, February 14, 2013, Valentine's Day. How sad and tragic. Pistorius shot killed his girlfriend Reba Steenkamp at his home. Pistorius acknowledged that he shot Steenkamp 4 times, causing her death, but claimed that he mistook her for a possible intruder. Prosecution believed that there might have been some domestic situation involved, and Pistorius just murdered her out of rage. Pistorius found guilty of culpable homicide. In October of 2014, he received a prison sentence of 5 years. On July 6, 2016, Pistorius was sentenced to 6 years. They increased his murder to murder, so they increased the sentence for that. 2017, the Supreme Court of Appeals increased Pistorius' jail sentence for 13 years. Oscar Pistorius is eligible for parole in 2023. Well, this case did not take place in the United States either, but it affected in some way. I remember this guy in the Olympics. I was kind of rooting for him. He was an amputee, competing against every other normal athlete, something you don't see every day. So I was rooting for the guy. News came out that he was arrested for murder. It shocked me. I told my dad. He couldn't believe it. I think he'll get out of jail. Part of me thinks he'll get paroled, but a part of me thinks he'll be in jail for the rest of his life. Just depends on what the court thinks of him. And, it depends on what the court thinks about it. If they think that he's ready to go back to society, they'll release him. But if they don't like him, he'll probably be in jail for his life. Number 2, one of the biggest court cases of all time, people of the state of California versus ornithologue James Simpson. O.J. Simpson, he was an American football running back, an actor, played for the USC Trojans, South Carolina University, won the Heisman Trophy in 1968, played in the NFL for 11 seasons with the Buffalo Bills, then he played for the 49ers, and became the first NFL player to rush for more than 2,000 yards in a season. He was inducted into the College Hall of Fame in 1993 and the Pro Football Hall of Fame in 1985. In 1994, Simpson was arrested and charged with the murders of his wife, Phil Brown Simpson, and her friend Ron Golden. Trial began in 1995 with Judge Lance Ido presiding. The 2 lead prosecutors were Deputy District Attorneys Marsha Clark and Christopher Darden. The prosecution argued that domestic violence within the Simpson-Brown marriage culminated in her murder. Simpson hired a team of high-profile defense lawyers: Robert Shapiro, John A. Cochran, F. Lee Bailey, Robert Kardashian, Alan Dershowitz, Robert Glazier, Gerald Yeoman, Carl E. Douglas, Sean Hooley, Barry Scheck, and Peter Newfield. They were called the Dream Team, and they were. O.J. Simpson, he was a rich man. From acting in films and playing football, he got the best attorneys. And so he should. You're facing a double murder charge, and the prosecution's probably going to seek the death penalty against this guy. You got to bring out the best you can. He did. This was a dream team. You got Robert Shapiro, he's mostly a plea bargain attorney. Cochran mostly deals with civil rights cases and police brutality cases. Dershowitz is an appeals attorney. Gerald Gilman's from Harvard. You got Barry Scheck and Pete Newfield, who are in charge of the Innocence Project. This is a tough team to beat. You got highly experienced attorneys in the different areas. It's very hard to beat this guy with all these lawyers behind him. That's one of the reasons why he was acquitted. Without these lawyers, I don't think he would have been acquitted. I mean, he was convicted in his robbery trial. He was sued. These attorneys, they're really good, and they're the reason why he won. The defense argued that DNA evidence against Simpson was mishandled and planted by police. October 3rd, 1995, Simpson was acquitted on both counts of murder. O.J. Simpson's key victories for acquittal are the defense did play the race car. Trial took place after the Rodney King beating. Jury was mainly black. The prosecutor was female. At that time, females weren't really seen as strong figures, and they were kind of despised as being, being in high-profile professions and situations. Mark Furman, the lead investigator, lied about making racist comments, and the bloody glove at the scene did not fit, which led to Johnny Cochran's famous saying, "If it does not fit, you must acquit." O.J. was sued by Fred Goldman in 1996. 2008, Simpson was convicted of robbery and paroled 9 years later, 2017. And since the case ended in acquittal, the O.J. Simpson murder case is still technically open. Now, he can't be charged with murder because of double jeopardy. But however, a friend of Ron Goldman, Michael Nigg, was murdered, and his murder could be connected to Ron Goldman. For my thoughts, I think O.J. Did not do it. I think someone else did. I think Michael Nigg did have a connection to Ron Goldman. Maybe they did a drug deal with someone, and that's how both of them got killed. They did a drug deal with someone sought revenge and killed Ron Goldman and his friend. But I don't think O.J. did this crime. The LAPD, they looked really bad after the Rodney King beating, so they won an easy win by locking up O.J. Simpson, America's favorite football player. That didn't happen. I think someone should take another look at this case. I think someone should. Number one, this had to be number one since it was the most recent one. It's the state of Minnesota versus Derek Chauvin, May 25th, 2020. George Floyd was killed while being arrested on suspicion of using a counterfeit $20 bill. During the arrest, Derek Chauvin, a police officer, knelt on Floyd's neck for 9.5 minutes. After he was handcuffed and lying face down, 2 other officers assisted in Chauvin in restraining Floyd. A 4th police officer prevented bystanders from interfering. The following day, videos made by witnesses and security cameras became public. All 4 officers were fired and arrested. Chauvin was later convicted of 2nd-degree murder, 3rd-degree murder, and 2nd-degree murder. 1 year, 1 month from then, June 25th, 2021, he was sentenced to 22 years in prison. Chauvin's civil rights charges, along with the other officers' trials, are still pending. The death of George Floyd caused worldwide protests and riots against police brutality, police racism, and lack of police accountability. Many police reforms were passed, as well as the disbandment of police departments and restructuring of policing in America. Folks, there's been 50 court cases that shaped America. These cases have all shaped America in some ways and are just as equally important. To me, this was a great video and a project that I had to do. Thank you all for watching, sticking around. Please subscribe for more videos.